says, in its judgment on the 23rd of September 2017, the special chamber decided as follows. Number one, unanimously finds that it has jurisdiction to delimit the maritime boundary between the parties in the territorial sea, in the exclusive economic zone, and on the continental shelf, both within and beyond 200 nautical miles. Number two, unanimously finds that there is no tacit agreement between the parties to delimit their territorial sea, exclusive economic zone, and continental shelf, both within and beyond 200 nautical miles, and rejects Ghana's claim that Cote d'Ivoire is estopped from objecting to the customary equidistance boundary. Number three, unanimously decides that the single maritime boundary for the territorial sea, the exclusive economic zone, and the continental shelf within and beyond 200 nautical miles starts at boundary point 55 plus with the coordinates 0523.2 north, 030621.2 west in WGS 84 as a geodetic datum, and is defined by turning points and has a lot of numbers. We will show you some of these on the screen. Number four, finds that it has jurisdiction to decide on the claim of Cote d'Ivoire against Ghana on the alleged international responsibility of Ghana. Number five, finds that Ghana did not violate the sovereign rights of Cote d'Ivoire. 6, finds that Ghana did not violate Article 83, paragraphs 1 and 3 of the Convention. Number 7, unanimously finds that Ghana did not violate the provisional measures prescribed by the Special Chamber in its order on 25th April. However, two judges, ad hoc judges, had some variances to what happened, and we'll go into all of that. So there we have it, and let me start with you, first of all, Dr. Kamal-Deen Ali. What were the antecedents for all of this? Just to put it in perspective, as to allow people to understand what's been going on. Give us a brief history of all of this.
To put the case in context, I think I'll say that as two coastal states, Ghana and Cote d'Ivoire both have interests at sea, and that interest is to extend their jurisdiction and their control into the sea, and within the jurisdiction and control is also their economic and resource interest. And this is just not something that is assumed, but it is something that is very fundamental to their interest. So it is not by accident that Article 4 of our Constitution as a country states, in part, that Ghana's sovereignty extends to our territorial sea.
Yes.
That is indicative of the fact that as a country, we find the territorial sea to be important for us as a country. Article 4.2 went on to state that Parliament of the 1992 Constitution, Parliament shall by legislation, may by legislation rather than shall, delimit the contiguous zone, the exclusive economic zone, and the continental shelf. This coming in the very early part of our Constitution and embedded within the title Territories of Ghana conveys the importance that constitutional as a country that we give to our maritime interests. So similarly, Cote d'Ivoire and every other coastal nation will position themselves in the same way to make sure that they are able to extend their control to the maritime space and be able to derive benefit from the resources. So from a very practical point of view, all nations do this. And as states that are adjacent states, we at some point will need to delimit where our boundary is between us and Cote d'Ivoire, as much as we may have to do that with our other neighbors.
Like Togo
So significantly, both Ghana and Togo, both Ghana and Cote d'Ivoire were just acting in a way that is predictable, because they all will have to seek their national interests at sea, protect their vital interests. It can be security interests, but more importantly in this context, resource interests. And as we do that, we will need to delimit our maritime boundary.
Are we saying that since our independence in 1957, a few years before Cote d'Ivoire had their independence, we have not had a specific demarcation between these two countries, and we've prodded along on what?
It was, yes, at least now the court has decided so, because the first two rulings of the court on the three substantive matters that Ghana canvassed before the court points in the direction that there is no such a boundary. That is the import of the first two rulings on the two out of the three substantive cases that Ghana put before the court. But that is not because we are just not being studious as a country. There are fundamental reasons for that. Let's bear in mind that even what we speak of today as exclusive economic zone, as continental shelf, as defined now in international law, did not significantly come into existence, or were not undisputed in the form they are now until 1982. So between 1957 and 1982, both Ghana and Cote d'Ivoire did things to preserve their maritime interests. Some of these are captured in some of the legislations that we passed over the period. 1962, revision of our Territorial and Minerals Acts, and those ones. It was until 1982, when the Law of the Sea Convention was adopted, that we now have clearly the zone that we call exclusive economic zone in particular, and the current legal character of the continental shelf.
All right, let me bring lawyer Oppong in there. So let's look at Ghana's case, for example. The reason for institution of proceedings against Cote d'Ivoire. Ghana has brought these proceedings to resolve a maritime boundary dispute with Cote d'Ivoire. In bringing these proceedings, Ghana seeks to enhance further its excellent and close relationship with Cote d'Ivoire. A number of factors come to play, and that's what we want to look. What are the factors? Why do we bring these proceedings if in the past we have been able to somehow resolve these issues on our own? Why bring these proceedings?
Yes, it's true, and it is well documented that even as far back as the 1960s, we had attempted to resolve our boundary issues. And also sometime in 1970, we entered into a treaty of friendship and cooperation with Cote d'Ivoire. But all these resulted in the establishment of our land boundaries. But the maritime boundary had been left, as it were, unresolved, even though there had been attempts. Joint commissions had been established in the past to try and establish clearly our maritime boundary. So when you read Cote d'Ivoire's own final pleadings, which they delivered orally, and a copy of which I have here, they made a clear admission that, in fact, what they said, I believe that Cote d'Ivoire and Ghana have respected this text on boundary issues by setting up a joint committee for the redemarcation of their land boundary between 1963 and 1988. Then there was a second joint commission to establish the maritime boundary, which we were unable to resolve. But I think that the discovery of oil in commercial quantity at this enclave has perhaps been the final push or the impetus for us to then establish it, because now there is a matter of value there. Because when you look at the drawings and everything, it really turns directly on our location of the 10 fields, as we put it. And so I think that perhaps, but for the discovery of petroleum at that enclave now, we may still have entertained Cote d'Ivoire, and they may have also in exchange entertained us, because it's clearly stated by us, Ghana, and also the Cote d'Ivoire, the extent of our relationship, which perhaps we will also highlight subsequently, which doesn't really put us in a position where we will engage in adversarial proceedings. If this one wins, that other one loses, and vice versa, with all its unpleasant consequences. Even we lawyers sometimes hate litigation, because one person will lose and the other will win, and the one who loses goes home very bitter, and if it's not well managed, then there are problems. So we have entertained all these issues, including other things. But when it comes to land, the evidence is that we have actually settled substantially where our boundaries end and start and so on, where it straddles. We have clearly established it. So with this disagreement, even though I have held a view previously that we still had the opportunity, or should have had an opportunity
to have done this long ago,
to resolve it amongst ourselves, or maybe find a mediator where then there will be compromises. But we had to go with this quasi-court proceedings, which is adversarial, and which this one goes home very happy and the other side. But so because of our relationship in terms of consanguinity, affinity and so on, we were able to live together, even in terms of major languages, they have their French language, we have our English. We know some of our people even attend funerals there because they have relatives
common
there,
borders,
and vice versa. Okay, so it is the petroleum, and that is where maybe when we come the second round, we must also then situate this whole thing. To what extent may petroleum, which has usually created or been associated with some serious strife in tension feuds and things like that among even people in the same country, and maybe more serious even between countries. And as I'm saying, maybe when we come, but we have to also, for just to support what Doctor said, that our Constitution, Article 2576, clearly states that all minerals in their natural state, in or found on the land and in the continental sea territorial waters, are the property of the Republic of Ghana. And so you are talking about sovereignty, ownership, control. It's also important that you know exactly where your sovereignty starts and where it ends, whether it's for economic purposes, extraction of minerals and exploiting of other natural resources, or whether it's for fiscal aspects, customs and things like that. We need to clearly agree. But then I think fairly, in respect of those, there hasn't been many problems. Okay. That is this petroleum issue that may have engendered, in my view, may have engendered the necessity for us to then settle this matter once.
All right, let me bring Dr. Oduro in. Laura Oppong talks about sovereignty, and Cote d'Ivoire played on sovereignty a lot in this particular case. The fact that Ghana had overstepped its boundaries and all of that. Did Cote d'Ivoire have a point, really? Because this has been going on for so long, and there are accusations and counter-accusations as to who is in the right and who is in the wrong and who is in the know and who is not in the know, even at a point accusing Ghana of sidestepping the whole process.
Well, I think the tribunal was clear that Cote d'Ivoire had no case when it comes to accusing Ghana of abusing its sovereignty. But in the jurisprudence of international law, as far as the UNCLOS is concerned, let me also put this in the context that once it borders on the sea or maritime issues, it enters into the realms of international law.
Right.
And under international law, the last resort is to go to court, because you have the option of using mediation, arbitration, conciliation, and then negotiations. And I think Ghana and Cote d'Ivoire, we've gone through all of that, and Ghana thought that, look, let us bring finality to all of this. Thankfully, both Ghana and the Cote d'Ivoire are signatories to the United Nations Convention on the Law of the Sea. This convention, as Dr. Kamal-Deen said, came into being in 1982. In 1983, 7th of June, Ghana ratified it. 26th of March 1984, Cote d'Ivoire ratified it. So both of them, in international law, became subjects. We went to court, and fortunately, we were able to have our way. It is not as if we've had our way, but the court has really documented what is supposed to be the delimitation of the boundaries. Now, when it comes to sovereignty issues in international law, your sovereignty and your jurisdiction would have to extend within your continuous zone, exclusive economic zone, and the continental shelf. If these things are properly defined, then you have no problem. And I think that is where the problem came in. But I'm very happy that finally they have been able to resolve the issue. Now, what is left for us to do is go into implementation. As a nation, how do we document the coordinates? Because when we went to court, Ghana requested or asked for 3 reliefs.
Right.
The first relief is that they requested a tribunal to delimit in accordance with the principles and rules set forth in UNCLOS and international law the complete course of the single maritime boundary dividing all the maritime areas appertaining to Ghana and the Cote d'Ivoire in the Atlantic Ocean, including the continental shelf beyond 200 nautical miles. What it then means is that, yes, the space is there, but they are asking them to come clear when it comes to sovereignty within these areas. The second relief that Ghana sought from the tribunal is that they want the tribunal to determine the precise geographical coordinates. That is how come the tribunal came out with the coordinates and the points from A to F. They said precise geographical coordinates of the single maritime boundary in the Atlantic Ocean. And so it seems to me that the court responded to almost all these reliefs and then left Ghana and Cote d'Ivoire to go into the implementation.
All right, let me stay with you and take exactly some of the things that and discuss it. For example, the court unanimously finds that there is no tacit agreement between the parties to delimit the territorial sea, exclusive economic zone and continental shelf, both within and beyond 200 nautical miles, and rejects Ghana's claim that Cote d'Ivoire is stopped or banned from objecting to the customary equidistance boundary. If there were no boundaries, how then does the court come up with certain boundaries that now favors, or so to speak, Ghana in this point? If the court says there were no boundaries, how did they define those boundaries?
I think, you see, the court never said there were no boundaries, but the court indicated that in their view, there was no tacit agreement.
Okay, for the boundaries.
For the boundaries,
Right.
because when you look at international law, like the Nicaragua versus Honduras case, I mean, the standard for coming up with tacit agreement relating to boundary dispute is very high. And in my respective view, I think that Ghana could not discharge that standard or that obligation on Ghana. That is why they thought that, look, you have over-relied on this so-called agreement between the two of you. But we think that if you would test it at international law, it will not fly. So using that one as a baseline, let us then use the equidistance principle or methodology to redemarcate and then come up with the coordinates as Ghana has sought for.
So would you say that Ghana was illegally exploring, drilling oil in a place where there was no tacit agreement? Would you say that's what Ghana was doing?
No, I would not say that, because Ghana was also relying on some form of agreement that they thought would fly when it comes to international law. And Ghana was also operating within its contiguous waters, continental shelf, and exclusive economic zone. So at that point in time, Ghana was determined by international law. With the exclusive economic zone, continental shelf, and the contiguous zone, we have a way of determining. So that one is known under international law. So Ghana has all this period relied on the presumed existence of a so-called arrangement between Ghana and Cote d'Ivoire. All of a sudden, Cote d'Ivoire said, no, that is not it. Let us go to international court. You go to international court, they subject this so-called agreement to the international standard, and it does not meet it. So then it becomes a duty of the court to redefine it using the baseline to bring finality to bear. Let me also mention that under the statutes of international, the UNCLOS, it is clear that it is the duty of the court to ensure that they resolve this issue, to bring equity to bear in the process. So in my view, though it may seem that Ghana has won marginally, Cote d'Ivoire did not lose that much, because all the oil fields that were within Ghana's territorial waters are still within Ghana's territorial waters. So yes, we've won, but Cote d'Ivoire has not also lost that much.
I think that is a point we need to make clear.
And I think a bit of some internal inconsistency in even the judgment.
Right.
Because Ghana presented a case and said that our boundary, we have always identified our boundary to be equidistant.
Right.
All right?
Yeah.
So it's there. Cote d'Ivoire said no. Use the 168.7 degrees.
The angle by
that
sector.
way. Yeah. And the commission, the court, affirmed Ghana's claim,
The equidistance.
which has been the position we have held
From the one.
over the years. So why do you affirm this claim and still say that we were unable to prove? What we were unable to prove in the view of the court is not that we were wrong when we said that when you use the equidistant, this is what we get, but rather that there had been an agreement between us and Cote d'Ivoire. But the agreement comes in various forms. As I said, tacit, constructive, actual, and even by estoppel. We have started drilling for a number of years, at least a couple of years. You've sat by, slept on your right somehow, only for us to be challenged when we have discovered petroleum in commercial quantity. As I said, even though there had been previous discussions, but in reference to this particular enclave, that's why I said that it is the discovery of the petroleum that actually engendered it. So that can itself, and that is where equity also comes in. And there are a number of margins of equity.
Right.
It is the vigilant, not the indolent.
Yes.
For example.
Yeah.
So all these, I think, also may have influenced, because so the court actually agreed with the position Ghana has held over the years. Because when you look at, a couple of people have tried to draw the map by using Google, you will see that the very line which we drew and presented to the court was the exact place where the court itself.
I think we have the map. So if the
yes, when they come
okay, it's on the screen now.
Yes,
the map is
so
on.
Yeah.
So in my view, that was the case Ghana brought. So we took it that once we have, and I think one of the judges, one of the ad hoc judges,
Yeah.
I think Pike actually said that the proper term is that it was attributed to us, where the line has been drawn now, or where has been affirmed. It was attributed to Ghana, and not that Ghana owned it, or Ghana.
So by who?
Yes.
That's the point.
Yes, so we by tacit agreement over the time, over the time, and so the tribunal, in my view, even if they did any work in respect of surveying and redemarcating, it still confirmed Ghana's position because it never shifted substantially, if at all, in my view.
No,
so you affirm our case, and at the same time, it being said that the court rejected our position. If I do a thing continuously, unless it's an illegality, which cannot metamorphose into a legality, then you will be fixed with an agreement, whether in terms of estoppel or not.
Yeah.
Of course, estoppel can also be subject to law.
Right.
We know that. But until you get there, then I will be right in having that attribution to me. Invest huge sums of money in these areas. Only when these huge investments start yielding results, positive results, then you get up. It's the same principles the court even used to reject some claims by persons in respect of land claims or land disputes.
Okay.
You understand? So that is how I see the agreement, in terms of they may be looking aside whilst and making it seem as if there is some agreement that this is where our land or our territorial waters start and where it ends.
Okay, Dr. Kamal, you wanted to contribute to
I
this,
want
and
to
then I'll
contribute to what my colleagues are saying. Let's look at it this way, because you've asked a number of questions. Within the law of the sea framework and within in the delimitation, you may be adjacent states or you may be opposite states. In the case of us and Cote d'Ivoire, we are adjacent states. Now, you are required under the law of the sea framework as states to determine your maritime boundary by agreement. Remember that there's a cardinal principle of international law that all boundaries, whether land or maritime, must always be by agreement. There cannot be a unilateral declaration of a boundary. So for that matter, our land boundaries are based on agreement, and Council has referred to some of the effort in the past to achieve that. So in the maritime sphere also, Article 83 of the Law of the Sea Convention, we must, by agreement, delimit our maritime boundary, which is the boundary that we share with Cote d'Ivoire, by agreement. And it went on to say that taking into consideration international principles and also the principle of equity. But it also went on to say that pending agreement, the two states should respect the median line. They should respect the median line. Now, generally, the median line is also close to an equidistance. So the reality is that both Ghana and Cote d'Ivoire were respecting the median line. To some extent, that is why it was very difficult for us to always argue the tacit agreement points that we're canvassing. Well, in reality, we were both enjoined to even respect the median line. And to the extent that that line we were calling a tacit line was the median line, Cote d'Ivoire can always say that respecting that median line was not out of accepting the position of Ghana, but they were even enjoined under Article 83 to respect the median line. So it is that median line that we have respected, which coincides with the equidistance, and we are saying that that median line then translates by our respective conduct into a tacit agreed boundary.
Right.
And in doing that, we advanced a number of arguments, but the court rejected all those arguments. We reject our oil and gas practice, the way we have issued blocks, our respective national legislations where we all refer to it. The court rejected that and equally rejected the estoppel. So what then the court had to do in this case is exactly what he said. Okay, if there is not a tacit agreement, because a tacit agreement would have meant that the court will have to confirm that. The court will have to confirm that. So if there is not a tacit agreement and the parties agreed also, then construct a boundary for us. But the good thing in this case was that the so-called tacit agreed boundary also was the same boundary that is an equidistant boundary, and which was also the median line. So to that extent, once the court went to the third leg of the case to construct an equidistant line, which is done not based on the conduct of parties, but which is done geometrically, it ended up being the same line, more or less, the same equidistant line.
Very, very interesting right there. I mean, you can join us in the discussion as usual on our WhatsApp platform 0555131288, either by text or by WhatsApp 0555131288. Now, you mentioned Judge Park, the ad hoc judge, and I want us to I just want to read something that I found very interesting in his what he said. He says, I voted in favor of the conclusion contained in operative paragraph 6 that Ghana did not violate Article 83, paragraphs 1 and 3 of the convention, which is what Dr. Kamal has talked about. But my vote requires some explanation, especially with respect to the question as to whether Ghana violated Article 83, paragraph 3 of the convention. Operative paragraph 6 is a reply to final submission number 2 of Cote d'Ivoire, in which Cote d'Ivoire requested the special chamber to declare and adjudge that the activities undertaken unilaterally by Ghana in the Ivorian Maritime area constitute a violation of the obligation not to jeopardize or hamper the conclusion of an agreement as provided for by Article 83, paragraph 3 of UNCLOS, emphasis added that the United Nations Convention on the Law of the Sea. I had to reject this submission and vote in favor of the above operative paragraph strictly because the activities undertaken by Ghana did not take place in the Ivorian Maritime but in an area attributed to Ghana, as the special chamber indicated in paragraph 633 of the judgment. Leaving this formalistic reason aside, however, I have a serious reservation, and this is the judge, Judge Pike, about the lawfulness of Ghana's activities in the disputed area in terms of Article 83, paragraph 3 of the convention. I also find the reasons given by the special chamber in support of its conclusion insufficient and unconvincing. This is an ad hoc judge who sat on the panel, who had his own reservations as to the activities that we are doing in that area which we claim as ours.
Yes. You see, Article 83.3 says that pending, whilst parties are engaged in the course of negotiating their maritime boundary. Well, the whole article deals with trying to settle your maritime boundary peacefully. And Article 83.3 says that whilst you are engaged in settling your maritime boundary, that is actively engaged in some form of negotiation, you should not do anything that undermines the course of that negotiation. So if you realize that in the case of Ghana, we started negotiations with Cote d'Ivoire in 2009, and much of our discoveries in the Tame field were in 2010, 2011, 2012. So whilst actual Ghana was in negotiation with Cote d'Ivoire, we were actively engaged in prospecting and exploitation within the zone.
Right.
The only thing good is that, to be honest though, in the beginning of the case, we didn't establish already a zone in dispute. There was some level of the fact that we think we didn't agree, Cote d'Ivoire didn't agree with the equidistance. So Judge Park thinks that at that point onwards, we shouldn't have been undertaking prospecting or exploitation or sinking wells. But the truth also is that there was supposed to be a smaller area of possible dispute between Ghana and Cote d'Ivoire, at least notionally, in the beginning, because Ghana was convinced that Cote d'Ivoire might accept the equidistance, but we may vary in what we choose as base points. But as time went on, and when Cote d'Ivoire argued the meridian and went to argue the bisector, it resulted in a larger area that became in dispute. And that larger area then covered the Tainsville. So it wasn't really a very deliberate thing that Ghana was doing to undermine the process, in my view, but we actually did things that notionally can be said to be undermining the process, because we were engaged in discussing a boundary, but also prospecting in areas that the other side could see might fall into their area if the boundary was delimited in another way. But that wasn't any deliberate contact on the part of Ghana, and indeed, it was Cote d'Ivoire that enlarged in the area of dispute through the negotiation process, and by 2014, Ghana then had to go to court. And one of the reasons was that Cote d'Ivoire used the negotiation process to enlarge in the area of dispute. And as the area of dispute became larger, it created more uncertainty for our oil.
Cote d'Ivoire simply wanted to stop the 10 project from happening.
Something you can put it.
Yes, sir.
Yeah, you see, I think what Doc is saying is clear. And let me, for the purpose of our listeners, our viewers, let me read Article 83.3. It's saying that pending agreement as provided for in paragraph 1, the states concerned, in a spirit of understanding and cooperation, shall make every effort to enter into provisional arrangement of a practical nature, and during this transitional period, not to jeopardize or hamper the reaching of the final agreement. Such agreement shall be without prejudice to the final determination. Now here, the court also indicated that throughout the issues, the two nations could not distinguish between oil concession boundary and maritime boundaries. Oil concession boundaries and maritime boundaries. And that is very important, because for us, Ghana, it's thought that there is a tacit agreement and we are going by that. And the area of dispute is not so about oil concession, it's about maritime boundary. So it is about maritime boundary.
So do you disagree with Lawyer Oppong when he says that the real reason for Cote d'Ivoire's insistence that we need to stop what we are doing in order for is because of oil?
No, I agree with you.
You agree with it?
No, they are both right. I agree with
Okay.
you. Except that they should have distinguished between oil boundary concession and then maritime boundaries. That needed to be done. But they were using the oil as a bait. They were just using the oil as a bait, in my view. Yeah, they were using the oil as a bait, you know. And I believe that is why the court also, in April, gave out the provisional orders. Yes. They gave out the provisional measures so that Ghana would have to respect it. So it would then resolve a number of issues. And I was happy in their final judgment. They indicated that Ghana discharged this obligation creditably. We respected the provisional measures, and that really supported us in one way or the other in coming this far with the case.
Okay. It's very interesting now. And now that judgment has gone in favor of Ghana, what's the next step?
Oh, thank you. Well,
I mean, it doesn't end there. I mean, people think that's it. It's ended.
honestly,
But it hasn't ended.
I hold the view, if I right from the day that this dispute became public, even before we were to go to the courts, I held the view that, once again, in view of the special circumstances that bond us as Ghanaians and Ivorians, we may have maybe ended the matter amicably. Of course, I understand, as you even repeated, there had been a number of occasions where about 10 attempts. That is just recently, but it goes back to the 1960s in any case. But my view is that a person doesn't really need to be at where the petroleum is actually located to be able to extract petroleum. In fact, we can decide to be here. There is something called diagonal drilling.
Yes, you put a rig there and you can decide to put a rig somewhere and drill your oil.
It's internationally declared to be
illegal.
An immoral, maybe not illegal, but an immoral way of extracting petroleum.
That's basically
and now
isn't it?
With technology,
being so close to the equidistance, that's exactly what Ghana is doing.
But they can also do that, and I'll be surprised if they haven't thought about that. Now technology abound, they can just be at their end, because petroleum straddles. It's not like something that is just static.
Yeah.
It moves from a place to the other, depending on the technical movements and the determination of all this. So, and that is the reason why I hold it. And I still maintain that this petroleum issue has really engendered this. Petroleum normally will last for 30 years. Normally, it will last for 30 years. Most of our agreements now are even 25 and so on.
And then you move on to another well and move on to somewhere.
And so I would rather that this 30-year bounty, so to speak, may not be able to pay for the risk we may incur in having other dispute, more serious dispute with Ivory Coast.
Such as what?
And that is what I'm coming to. You know, even though at the court, after the decision, the Ivorian team and the Ghana team, in fact, our Attorney General read a wonderful, profound address. In fact, even mentioning Cote d'Ivoire's name before she mentioned Ghana's name. Very commendable. But that is at the top. And I would be surprised that the two presidents may not have been discussed about this. They have. I think once a time, Kofi Annan, our own Kofi Annan of the UN, also made the point that the need for us to ensure that whichever way this decision goes, it is not going to be a mechanism to be exploited by some evil-minded people to draw a wedge between us because of the issues of consanguinity, even the location. If we don't manage this very well, we have seen dispute the 10 families into two. 10 families into two forever, for the rest of their, and not just even their life, for generations.
Let's open a Pandora's box here. Let's open a Pandora's box, because one of the things Cote d'Ivoire said was, for example, ships coming into their ports will now have to go through Ghana and may be subject to some restrictions and so on and so forth. They've also talked about fishing, the fact that fishing has been destroyed in areas around within their boundaries, and it just takes one stray, like you said, to reignite this whole conflict.
Don't forget that there have been a few such internecine feuds between us in the past. Even where football matches between us, people may have just used it to turn a whole serious problems amongst us. And I'm saying that because of these special circumstances, in law, parties can compromise judgment. Parties can compromise judgment. So, for example, when there are authorities to that, if a court grants me an order to recover 2,000 Ghana cedis that you owe me, the two of us can just agree after the judgment that, oh yeah, Oppong, just pay me 1,000 and I'll forgo the 1,000. If I subsequently decide not to pay you the 1,000, you cannot go to court to recover 2,000 for further order to recover 2,000 from me, because we have compromised the judgment, and that compromised judgment prevails over even the court's judgment. With bearing in mind, and that has been my position, bearing in mind that if it is not managed well, especially at the lower level, the so-called grassroots level, they just see us jubilating. Some are making some inflammatory statements to heighten passion and temper. Oil is a very sensitive matter because of the fact that if you don't have to do anything to it to get huge sums of money coming your way.
Let me bring.
So I'm just in conclusion, just saying that in spite of this victory and their loss, there are too many things that bind us together. That oil which lasts for 30 years should not be allowed to be the reason why it should be destroyed, because it will destroy us forever. So, and you are giving some examples.
Yes.
And of course, in all fairness, even Agalam say, Ivory Coast are complaining that it is having debilitating effect on the environment.
Right.
So, in the same vein, their activities can also have debilitating effect on us. I think that we still have the opportunity to apply mechanisms like mediation, so that even in the plot, we can still say that we have to comply with the court order. This is where the line is drawn. But the activities there can be managed separately in terms of the prudence. Look, they could even form a joint operating company.
I was just going to ask Dr. Kamal about, is it possible for us and Ivory Coast to decide that, okay, maybe 100 nautical miles on your side, 100 on side, let's do this together? Is it possible? Because this is not over yet.
It is legally over. It is legally over, and it is legally possible, what you ask also. But to put it as counsel is saying, in terms of relationship, you can never say it is over. So it is legally over because this is a final determination of the case. But it is legally possible. Nothing prevents us from deciding that we could compromise, as counsel is saying, compromise.
But you do know that behind all the smiles between Ghana and Cote d'Ivoire after the verdict was given and all of that, behind that, Cote d'Ivoire is going home not happy.
Oh yes, certainly.
You know that.
Yeah, certainly. But so that's why I'm saying that is a decision that can be taken at the highest level of the government to do that. I don't know whether that will be done or not, but it is legally possible, because it is us who may decide that, given the fact that we have this judgment, we will still want to do A or B. But and in doing that, a number of things can happen. You can shift the boundary and then give shift the boundary towards Ghana, or the equidistant towards Ghana, and then leave some portion for Cote d'Ivoire. You can decide to create a special zone around the area and call it either a zone of common interest, as in the case of Angola and DRC, or you call it a joint development zone. So you can do that. The third thing, of course, which can also happen and which may happen out of necessity, is that if in future Cote d'Ivoire makes discovery on their side of the equidistant, and we are also having discoveries now, and let's assume that those discoveries even come closer, the next wells come closer, then also there is a possibility of what we call unitization. Unitization actually is dictated by imperatives rather than what you agree, because once you have a common pool on each side of the border, as in the case of Nigeria, Sao Tome, then you enter into a unitization agreement. Unitization agreement can be with a legal agreed boundary or with a disputed boundary. In the case of Ghana, if we ever reach that point where all of us have made major discoveries on each side, we can have a unitization of the field. In the case of Nigeria and Sao Tome, they have an undelimited maritime boundary as we speak, but they have got a unitization because each unilaterally did something on the east side, and actually strategically done by Nigeria in this particular case, and that resulted in the unitization, although there is not an agreed maritime boundary. So these are the possibilities that are open, but in terms of this case itself, at the national level, we will then have to do some of the things that Dr. Oduro mentioned earlier. That one, we will have to now have a national legislation that more or less translates the decision of the court into a national instrument, because we now have to have a law. Remember, as I mentioned, already Constitution required Parliament to May by legislation, and May was used cautiously because Parliament could not do that unilaterally. So through some internal administrative processes, some bill may be presented to Parliament to now document those coordinates, and that will become part of that will then be seen as legally the limitation in the face of Article 4 of our Constitution.
Okay, Dr. Osae, what's the way forward now? What would you do if you had that opportunity after this verdict to advise, say, the president or somebody who is at the top? What would you say? What would you do?
Three things. One, we should look at Article 84 of the UNCLOS. Article 84 of the UNCLOS is clear that in matters like this, the state party is expected to cause publicity of the charts and the list of geographical coordinates. So first, we have to cause it to be developed.
Right.
And I've seen a number of them flying. I've seen TALO developing one. I've seen GNPC developing one. Let us synchronize and then coordinate it. Let us come out with one geographical chart, one list that depicts the coordinates so indicated in the court ruling. Once we do that, we use that particular document to engage with Cote d'Ivoire, and then we sensitize people around that. Then after that, we will look at our maritime zone, we look at the fisheries, and then we will look at other areas within our exclusive economic zone and then the continental shelf. It's not all about oil. The maritime resources goes beyond oil. We have fisheries there. We have a lot of things in there. So as a nation, we have won this case. Going forward, let us document it. Let us go into enforcement or operationalization, as somebody would say. But let us also be thinking about securing our borders, securing our maritime waters between Ghana and Togo.
Quite interesting. I have a few minutes to go, and I'm going to give you each person 1 minute to wrap up on your final statements, and then we'll go from there. So I'll start with you, Lawyer.
Well, I think without sounding repetitive, I think that our two leaders should, as a matter of urgency, maybe start applying some diplomatic mechanisms, which I know they know best, and ensure that when things start settling and people want to regroup, especially those on the ground, the ordinary Ghanaians like the rest of us, will understand that Cote d'Ivoire has done nothing wrong, and Ghana has not, as it were, take away from them.
We haven't won, so to speak.
Their resources.
We've just
the
had a
court only affirmed
favor.
a position Ghana has always held, and we took the matter to court. We could have lost the case.
Absolutely.
And Cote d'Ivoire, we may say, has won. But in actual fact, we didn't win, and Cote d'Ivoire didn't lose.
Yeah.
Because our various positions our position has been affirmed. And Cote d'Ivoire's position, which he has also held over the years, have not been affirmed. Don't forget that the methodology they wanted to apply had been applied in the past, except that in recent times and in modern times, with the aid of technology and so on, the equidistance methodology appears to be more accurate and more in sync with modernity and if you like, appropriate technological mechanisms and things like that. So let us all understand that this is not about jubilation. Of course, also internally, there already has been attributions to this one started and this one has done it. This is not.
We play politics with everything.
Well, this is not the point. I mean, let us ensure that overall our two countries, because if there's unemployment here, it will affect Cote d'Ivoire and vice versa. Okay. Our two countries will will apply the appropriate technology in terms of even the environment, because they may be there, the activities can have serious debilitating effect on our environment. Let us try as much as possible to maximize the benefits of the extraction of petroleum, always bearing in mind the effect it may have on the environment for both countries.
All right. Dr. Osae, your final statement.
I think the energy with which the two political parties worked was phenomenal. And I expected us to carry that energy along and ensure that if we have similar cases or similar issues confronting us, let us tap into all the available human resources in this country. Let us put politics aside. Let us resolve issues that would benefit us as Ghanaians.
Okay.
That's what I can say.
And finally to you, Dr. Kamal-Deen Ali.
Two things. First of all, of course, the individuals and the team that have worked on it, are commendable. But also for me to use the conclusion to point a few things. That this has an implication for Ghana, Togo maritime boundary. It tells us what we may do and what they can do. At least it's an advice in a form to us, and then to enter into negotiation. This has implication for the larger region, because for the second time, equidistance has been pronounced for the region in the case between Bakassi, in the case between Cameroon and Nigeria, and for us. It also gives an indication that at the regional level, it is possible for us now to further bilaterally negotiate our respective boundaries, bearing in mind equidistance and adjusting that rather than waiting for future litigation. Because there are a lot of undelimited maritime boundaries in our region. In fact, there are only two delimited maritime boundaries. Ours now with Cote d'Ivoire and Nigeria with Cameroon. The rest are largely undelimited from here to Angola, from all the way from Liberia to Angola. So this is a pointer for this
maybe when we get Africa,
some form of
finally unite.
All right, gentlemen, thank you very, very much. I think that for viewers at home, we have tried to throw some light on what really happened, and I'm sure that you are better informed now. I've been talking to Dr. Eric Oduro, who is a governance expert and who is also a lawyer and from the local government, the Institute of Local Government. I've also been talking to Captain Dr. Kamal-Deen Ali, is the Director of Research at the Ghana Armed Forces Staff College, and also Mr. Oppong, who is a lawyer and a lecturer at Central University. My take on all of this is I think that we should take the initiative. Our President, if it is possible, with all due respect to Excellency, should fly over to Cote d'Ivoire and have a chit-chat, not to go and lord it over anybody, but have a sit down with President Ouattara and say, in spite of the ruling, we're still brothers, we're still friends, we share a common border, we share many, many things along the western border of Ghana and the eastern border of Cote d'Ivoire. So I think that it is important for us to do that. We need to move fast. We don't have to leave. We also need to start talking to Togo as well. We should have a meeting with them as well. We could even form a tripartite meeting of the three countries and see how this goes. This is Talking Point. My name is J.O.T. Agyeman. See you again next week.